I'm going to ask you all to please take your seats. I know some of the best and most productive work that we do happens in conversations like you're all having now, but we do want to continue with the second half of our panel. And I promise there'll be time for you all to talk later in the day. We are going to continue with our panel about reform efforts that are happening across the country today. I want to remind you all to take out those signs, write why you believe in the right to counsel so we can take pictures over the noon hour and tweet them out. With that, I'm going to turn it back over to David and Colette.
In the part B of our panel, we're going to focus on two states, New York and Missouri. New York is moving forward towards more and more state oversight, and there's a pending bill that will move to state funding of the right to counsel. And Missouri is one of the most structured states when you look at sort of how they provide services and how they have, but even those more structured states have difficulty. So on our panel today from Missouri is Michael Barrett, the state public defender, and I'll turn it over to Colette to start the New York discussion.
Great, thank you. Before I start with New York, I just want to give a shout out to David Carroll and the Sixth Amendment Center for the brilliant work that they did studying Indiana. NACDL commissioned the Sixth Amendment Center to do a report of 8 counties, and there's copies of the executive summary that are out there, and it was released yesterday, and it really kind of highlights some of the issues that we're talking about today in the right to counsel. I'm very honored to introduce our first speaker, who is Bill Leahy. Many of you may have known Bill Leahy. He's worn 2 hats. Bill Leahy was the chief deputy of the Committee for Public Counsel Services, the Massachusetts State Public Defender Service for like 30 years, Bill? A really long time. And he was my boss. He hired me in 1989. But Bill left in 2010. We had a big retirement party for Bill Leahy, only to find out that Bill Leahy was then going to New York to try to reform the public defense system in New York State, where he now serves as the director of the Office of Indigent Defense Legal Services for New York State, and he's tasked with ensuring that the settlement in the Harrell Herring case is being met in the counties in which it was served in. I just would also add one other caveat. One of the most profound moments of my career as a public defender was sitting in a courtroom in 2004 in Massachusetts when Bill Leahy was arguing the LaValle case, which was a complete work stoppage for bar advocates who were being paid some of the lowest wages in the country for an hourly wage. And there was work stoppage, and Bill Leahy argued so beautifully on the 40th plus anniversary of Gideon to ensure that every poor person who goes through the doors in Massachusetts is adequately represented by a fully funded, fully resourced public defender or private bar advocate. And as a result of the litigation in LaValle, it made huge historic changes in the state of Massachusetts. So I'm very honored to be able to introduce you and the work that you're doing now in New York. So Bill, I wanted to ask you, I should start with Corey, I'm sorry, because you're going to talk about the litigation first. Many of you met Corey this morning. She talked about in her role as the Department of Justice. Now she's going to take that hat off and speak to you all about the work that she did with the New York Civil Liberties Union and the work that the ACLU has been doing on some of these systemic litigation cases, but what happened, the fascinating story of Harrell Herring. So we'll start with Corey and then we'll go to Bill. So thank you, Corey.
Thanks. So yeah, let me reemphasize, I'm now speaking in my capacity as the former attorney for the New York Civil Liberties Union, not in my capacity as a Department of Justice employee. And in that capacity, I was lead counsel in the case Harrell Herring versus State of New York that challenged New York's system of abdicating its responsibility for Gideon to New York's 62 counties. And in that case, we sued the state of New York over the state of public defense in 5 counties across the state of New York, and brought a class action in state court alleging that the system was broken and was failing to provide adequate counsel under the Sixth Amendment. And in that case, we brought that case on the tail about a year after the chief judge, the then Chief Judge Judith Kaye of the New York State Court System, had issued a report calling the public defense system in New York unconstitutional and incapable of delivering constitutionally adequate legal defense to people arrested in New York State. And so as a ACLU lawyer at the time, we interpret reports like that as kind of a gold embossed invitation to please come in. But as responsible litigators, we waited first, and we hoped that there would be a political moment around that, and that the New York State legislature and the governor at the time would step up and take the steps that should have taken, that we heard other states like Utah, and Idaho legislators realizing the importance of reform and taking up that mantle and taking action. But that didn't happen at that time in New York. So we brought suit, and over the course of a hard-fought years of litigation, the case eventually made its way to the New York State, the highest court in New York State, the New York State Court of Appeals. And in 2010, there was a decision by Chief Judge Littman, wrote the decision affirming the constitutional right to counsel, and that the litigation could proceed. There were then several more years of litigation, and actually on the eve of trial, the case settled, and Governor Cuomo entered into a settlement agreement that really revolutionized the reform of those 5 county systems, and included the guarantee of counsel at arraignment, which was clearly established under the law, but was not honored in the state of New York as a matter of practice, especially outside of New York City, and established the requirement of caseload limits, and also raised the bar of quality, and in many ways, most importantly, brought the Bill Leahy's office, the Office of Indigent Legal Services, in to be the kind of executor of the settlement, and to ensure that the standards that were set for eligibility for caseload standards were high quality, and it really raised the bar of defense in those states. And what followed after that, and I think Bill will pick up the story from there, was then a legislative effort to ensure that those reforms, which by the boundaries of litigation were limited to those 5 counties, was then expanded statewide. Because of course there's no logic in having 2 different standards of justice for 5 counties because I sat in a room one day and decided those 5 counties were going to get sued. That's not the way we make public policy. So that story is ongoing, and I think Bill will pick it up. But that, in a nutshell, was the story of Hurl Herring, minus the most important part of the story, which is that on that eve of trial, the Department of Justice filed a statement of interest in the Hurl Herring case. And that was a critical moment in the progression of that case. I think, now having seen that process on both ends, it's really been an extraordinary opportunity, because as a litigator at the time, I was on that, and many of you have been in that kind of that black hole time where you kind of know that maybe it might happen, but you don't know anything about whether it would happen. You don't really know what's going on and what they might be thinking, and then just one day it happens out of the blue, like a bolt from the blue. And it was a really transformative moment. We were in the middle of settlement discussions when that happened. I can tell you it was a very different morning when we walked into that room in the midst of those settlement discussions the day after that happened. So there's really no question in my mind of the tangible effect that the filing of that statement of interest had on advancing reform in New York. And so that was a really important moment, I think we would not be where we are today in New York without that as one of many necessary ingredients to reform there.
I wanted to ask you how you made the choice to sue just 5 counties versus the entire state, and how you chose those 5 counties.
New York has 62 counties, and that's a lot. And and they're very diverse. You have 5 counties that make up New York City, and that, is an endemic feature of New York, is that that's just one-off. That's kind of, there's nothing like that. And then you have other kind of urban counties with kind of, big cities in it, Syracuse, Buffalo, Rochester. And you have really rural areas. I don't know that we have the frontier. It's not, I know, but we definitely have rural counties with, there's dairy farming, lots of farming in New York. And so what we aimed for, I mean, just to be perfectly honest, the reason we didn't sue 62 counties is anyone who's a litigator actually already knows the answer to that question. We have a burden of proof, and as litigators, we took that seriously. We knew that we weren't going to be able to coast in there and just kind of get away with it. We had to establish the evidence, and to do that in 62 counties would have been just impossible, and not feasible for for any nonprofit organization, even with the generous assistance of Schulte, Roth, and Zabel, who was our cooperating counsel in that case, who already spent literally millions of dollars, over $10 million over the course of that litigation just during those 5 counties. So that's why. So what we aimed to do was to pick 5 counties that were representative of the state. We picked Suffolk County on Long Island, so kind of very populous and lots of municipal centers, but not one big city, but a big criminal justice system out there, high volume. We chose Onondaga County, which is where Syracuse, New York is. Again, pretty high volume and a real city with the problems of cities and the crime patterns of a city. We chose a very rural county where there was mostly a kind of farming community there. And we chose a kind of suburban city near Rochester, but not that close to Rochester, to kind of give that kind of, all the different kind of demographic, geographic flavor of the state. And also within New York system at the time still delegates to counties the option to choose how you want to structure your public defense system. So you can have a public defender, you can have a legal aid society, a nonprofit that's kind of like we do mostly in New York City, or you can have a what we call a signed counsel system. Sometimes we call it 18B, which is after the New York State statute that creates that, where it's just private bar, rotating list. And each of those counties did that differently. And so our aim was to show that this was a New York State problem by taking, 5 counties that you couldn't say this is really about counties that are just assigned counsel systems, and we all need legal aid, and that would solve the problem. Or really this is a urban problem or a rural problem or a Long Island problem or just a Western New York problem. This was a New York problem. And we hoped to get a statewide solution out of that, which isn't exactly how it went down, but story's not concluded yet.
I was going to ask about that, but I'll hold off on that for the moment, because it looks like in June of 2016, the New York State Legislature had unanimously passed the Public Defense Mandate Relief Act. Oh, sorry, you can't hear me. In June, they passed unanimously the Public Defense Mandate Relief Act, which Governor Cuomo still has on his desk. I want to turn to you, Bill, because after the brilliant work that the ACLU, or New York Civil Liberties Union, did to get this result or the settlement, then you have the hat of ensuring that the settlement is actually put into place. Can you describe a little bit about what you were mandated to do and how that's worked?
Yes, I can do that, but before I do that, if it's all right, Colette, I'd like to set a little bit of a different scene, the pre-2015 implementation process, because we've been in business since 2011. Our new office is a brand new office that New York State created. For the first year, there were 2 or 3 of us, and then we eventually got to 10, and as a result of the lawsuit settlement, we're up to 19 employees right now. For the first 4 years or so of our existence, we had very little authority. We had a lot of resemblance to the commissions and panels you heard about in the first panel discussion. And it's kind of remarkable thinking back about what we were able to do. We created standards for criminal and parental representation, for appellate representation. We're at work now on assigned counsel program standards. We worked with the counties and with their county providers. Understand now, outside of New York City, 57 counties, ranging in population from 1.5 million in Suffolk to 5,000 in Hamilton County. We've got 15 of those counties are larger than the state of Rhode Island. We've got 20 of those counties have under 50,000 population. So we may not be frontier, but we've got a lot of country. We've got 80 institutional providers in those 57 counties and 58 assigned counsel programs, some of which exist in name only, but that's what they are. So 138 programs. And we don't have a club to beat them over the head with. We don't have, we're going to cut off your funding. What we have is expertise, we have dedication, and we have clear, here's our deal with the 57 counties. And the deal is simple. It's in two parts. There's a certain amount of state funding that you're accustomed to receiving, and you don't have to answer to anybody as to how you spend it. Now you have to do two things. You have to consult with your local indigent defense providers as to how that money should be spent, and the conversation has to be about how quality can be improved with that funding. And on that latter score, you have to satisfy us. And we are going to work cooperatively with you. We're always going to get to yes. So with that model, and also with a couple of competitive grants, we have been able over these 4 years, from 2012 to 2015, really before the settlement, to increase public defender staffing by about 16% upstate, to increase support staff, including investigators, social workers, sentencing advocates, by 20%, to reduce caseloads from wildly excessive to simply excessive, low 700s to high 500s, if you want the rough numbers. We've got a network of 6 regional immigration assistance centers, which provide a statewide approach to helping lawyers comply with their obligations under Padilla versus Kentucky. We've had 2 major state conferences on parental representation. We're about to put out an RFP for a model upstate parental representation office, which is explicitly modeled after the very successful programs that have been operating for about the past 10 years in New York City. So there's a lot going on that's positive with very little money, because this is not all about money. There's money, and that's important and vital. There's also structure and expertise and buy-in. So that's all pre-settlement. Now the settlement came down, and Corey's quite right, 5 counties. Well, another reason that at least the settlement with 5 counties, a big plus of it is, it allowed the settlement, because it was limited, to be really good. It's a really good settlement, and there's 4 components, right? There's counsel at arraignment. I came in from Massachusetts. I had no idea that my neighboring state did not have counsel at arraignment, because like a lot of people from outside New York City has it, so that must mean everybody has it. No, upstate New York did not have it. We're 5 years in, and we're nowhere near finished, but we're making a really good start. But in the settlement, it's guaranteed and it's state funded, and we're implementing it in the 5 counties. Not easily, because the system is cumbersome. And I haven't told you yet about the 1,300 town and village courts, which are presided over by 2,200 judges, most of whom are not only not lawyers, but no minimum educational requirements. Okay, so that's New York too. So back to the settlement though. Counsel at arraignment, excessive caseloads. And there we're in the middle, and I apologize, Andy Davies, who's a member of this consortium, he can't be with us today. He's our director of research. He's neck deep in our caseload study that we're engaged in right now with our contractor, the Rand Corporation. We've got a December 1st deadline to produce caseload standards for the lawsuit, for the providers in the lawsuit counties. That's exciting work and important work, and that's ongoing. That's number 2. Number 3 is something called quality improvement initiatives, and this is Corey's key contribution to this settlement. This is all about, do lawyers have the time, and do they have the resources, and do they have the impetus to act like real lawyers for the real people they represent? And that's, enough time to have a private conversation with your client. What a thing. What a revolution. Access to investigators and experts, time to do legal research and file legal motions. Again, acting like real lawyers. That's the third key component with funding in the settlement. The fourth is eligibility. All the three previous ones I talked about are trying to move the needle from having inadequate counsel to having adequate counsel or high quality counsel. The fourth one is really insidious. It's denying people counsel on spurious ineligibility determinations and having no state system. So here the settlement went beyond the 5 counties, and it took in all the rest of New York State outside New York City, where ineligibility is not thought to be much of an issue. And so we have now produced eligibility guidelines for the entire state. And one of the things we've tried to do is put presumptions in place so that you don't have public defender offices and courts which are utilizing resources which are supposed to be going to providing counsel and providing justice into determining eligibility. So we've got a presumptive eligibility if the applicant is under 250% of the federal poverty guidelines, and there are a host of other reforms in place. But the key thing is there is now one consistent eligibility standard in New York that is also under the settlement. So the settlement is in full force. It's moving ahead. There are obstacles. We have 8 people. We have an 8-person unit that was not part of the settlement, but it was funded by the state as a result of the settlement. We sometimes say that we could use those 8 people in just one of the 5 counties, but we're making very good progress, I think. And the other result of the 5-county decision is that there has been this political reaction. What about the rest of us? How can the state say that it has and accepts its responsibility for 5 diverse counties and not the other 52 that lie outside of the city? And so that's led to the passage of the bill by the legislature in June that Colette mentioned.
You know, what you have described in New York is similar to what we've heard in Idaho, Utah, Washington State, the constructive denial of counsel. When you come in and you have these mandates, is it hard to get the culture shift in the defenders, in all the stakeholders actually in the criminal justice community? Has it been very difficult to get buy-in from everyone?
It depends. I mean, I like to use expectations rather than culture, because I think sometimes people don't want their culture changed, but they're willing to change their expectations. But yeah, I mean, there are negative reactions when people perceive, for example, eligibility standards to be too inclusive or too expensive. Money is always an issue in public defense. It's a dirty little secret that good lawyering costs money. You know, if you go to hire a good lawyer, cost is going to be an issue. There's this kind of expectation out in too many areas in the political realm that good lawyering in the public sector somehow doesn't cost money, but it does.
Yeah. Thank you.
So for most of the panel, we've been talking almost exclusively about litigation and legislative efforts, but they're not the only 2 strategies that can be employed when looking to bring attention to indigent defense crises. With that, I'd like to open it up to Michael Barrett, the State Public Defender of Missouri. Michael, what was the stresses that your system was facing? What was the strategy you employed? And most importantly, why did you choose that strategy?
Well, sure. Just so for everyone's benefit, a few months ago, we were facing funding that was second to last in the United States, where 49th Mississippi is 50th in terms of the funding dedicated to indigent defense. Our caseloads across the state and our 31 trial offices, made up of 376 attorneys statewide, had risen from 74,000 cases last year to 82,000 cases. We weren't seeing any new money. We have a very conservative legislature that gave us the largest increase that we've received in more than 2 decades of $4.5 million. Still wouldn't have advanced us from 49th to 48th in terms of indigent funding. That's how far down we are. But nonetheless, it would have provided substantial relief. The governor withheld that funding from us, said that revenues weren't coming in as expected, and cut the money from our budget. I perused our statutes, 600-042 sub 5, and a never before used statute says that the director of the public defender system has the authority to appoint any lawyer in good standing in the state to represent an indigent client. And I said, well, we're going to have to start using this, and shouldn't we start with the one person in the state that's causing this problem? And so I appointed the governor, as many of you know, and that's only because we needed to bring attention to this problem. We needed to bring attention to the fact that during his tenure from 2006, when the Department of Corrections budget was $575 million, which is no small chunk of change for Missouri, increased to $727 million. This is an average of $30 million per year, and no one blinked an eye. We needed to call attention to this. You know, sometimes people say, well, where's the money for public defender systems? It pays for itself. Just from the 1 year, 2006 to 2007, the Department of Corrections budget increase, just the annual increase, was $45 million. That's $5 million more than my annual operating budget. So we needed to pull attention to this, where the rising prison costs, 150 million over 10 years increase, and not a single new dollar for the public defender systems. And you start looking at the bottom states in terms of the bottom 10 states in terms of public defender funding. And by and large, those are the same states that are top 10 per capita in prison funding. So the correlation is obvious, and we need to draw attention to this. And I think we succeeded in that. He hasn't released the funding, so we have that to deal with. But we had to resort to that, something of a political maneuver, because no one else was paying attention. And I think in Missouri, we got the conversation started.
And what do you see as the strategy moving forward from this point?
Well, I think the strategy for us is much like Texas dealt with in 2008, and it became a fiscal discussion, and I think that's where we are in Missouri. It's a very fiscally conservative state, and the argument on providing the right to counsel because it's the right thing, and the need to have a balanced system of justice where there's equal rights under the law, that train has left the station, and it's not resonating with legislators and governors in my state. What does resonate is the fiscal argument, that increase of the Department of Corrections budget that I talked about. Also, the cost to the counties. We talked about New York having 62 counties, and even there, for a state of 19 million people, the general consensus is there's too many counties. Now, by contrast, Missouri is fewer than 6 million people, and we have 114 counties, a very sparse population. And so there's lots of counties, and the biggest operating expense for the counties is their local jail, okay? Their local jail. They can't afford it, but they want it. And because the judiciary kind of wholesale ignores bond limitations, they put that, most people get, if you're poor, you get incarceration pre-trial, and that's just the way it is. But at the first day that they're in jail pre-trial, the county starts accumulating costs, significant costs, particularly if there's a mental health issue or a drug addiction. And these are costs that the county simply cannot sustain. And I think Missouri is unique in this. I may be wrong, but there's one policy that's at the heart of this whole problem. And that is the way that a county in Missouri gets reimbursed for their jail costs is if the person ultimately gets a state prison sentence. Think about that for a moment. There's a financial incentive for counties to sentence someone to state prison. And so the county electeds, the sheriff, the prosecutor, and the judge are no doubt at the Elks Lodge on a Friday night having Bud Light saying, we need some money. We got to balance our budget. You got to give these guys a state prison sentence. And that's invariably what happens. So 2 years ago, or 3 years ago, when during the State of the Union and the president said it was the first time in recent memory where the national prison population went down contemporaneous with the national crime rate, well, Missouri, that didn't happen. In fact, our crime rate went up, particularly violent crime, as did our prison population, and we are now knocking on the door of needing a new prison at $140 million plus FTEs. So my argument is now a fiscal one. You want to avoid having to buy that new prison at $140 million, and Missouri's not really looking to do massive criminal justice reform? Well, fund the public defender system, which is oftentimes not part of the conversation when we're talking about righting the ship on mass incarceration. Just to borrow a simple sports metaphor, if you're a hockey or a soccer fan, pull your goalie. Pull your goalie. And there's going to be a lot of balls going in the net that shouldn't go in the net. Same is true with the public defender system. If you have, as we do, 82,000 cases, which represents 250 cases at any one time for a public defender, you cannot provide substantive representation for them. And you, by and large, you are just meeting and pleading them, and the prison population, as a result, is artificially increasing.
Most people will agree that there is a focus on criminal justice reform in this country. And in many ways, your state was ground zero with Ferguson. Can you talk about how the right to counsel plays into this larger narrative of public safety and over-incarceration and the focus on where things are going coming out of Ferguson?
Sure. As many of you know, Ferguson gave rise to a pretty robust discussion, not just on the use of force with respect to law enforcement, but also the chronic and systemic abuse of fines and fees on the indigent population. In Missouri, we're a low tax state, okay? The death knell for any politician is to suggest, even in jest, to raise taxes for needed services. And so the way they fund government, particularly local government, is through excessive fines and fees. And so in Ferguson, which is one of 90 municipalities that make up the larger St. Louis area, you have these very, very small governments that represent not a very large tax base that are entirely funded based on fining and feeing someone. They don't cut their lawn, $50. They don't pay their fee, $75 service charge, so on and so forth. And then when they get pulled over, they're invariably housed in the local jail for however long. And then wouldn't you know it, when they're too poor to get out by making bond, they're responsible for their own jail stay to the tune of $40 per day. So it's a little bit of a head scratcher. I think in addition to the fiscal argument, we need to talk about how public defenders play a role in the larger public safety discussion. In the adversarial system, public defenders, only if we're funded adequately, can help the system distinguish between who they need to spend money on and who they don't need to spend money on. Probation and parole and corrections, it's really expensive, okay? The last thing you want to do is waste those finite critical resources on individuals who don't need it, okay? It keeps you from doing things on the front end, like eliminating your rape kit backlog, or executing warrants, or solving unsolved violent crime. And so what the public defender system does for the larger public safety discussion is, through the adversarial process, we're going to help you figure out who you don't need to pay attention to and who you do need to pay attention to. And and oftentimes that's not discussed. That's not part of the discussion. I think we need to make it part of the discussion.
We're coming to a close of this panel, and as we did in the first segment, we want to open up to anyone who has a question of the panelists here. Yes.
First of all, I want to congratulate Michael on his courage in taking on the governor. And I will note that the governor, in a blatant political move, appointed 2 sheriffs to your board, which diminishes somewhat your independence, and I hope you survive it all, because I thought it was a wonderful move. But my question has to do with your the case weighting study that was done by Reuben Brown in Missouri, and how that might play into the acceptance of the need for funding, whether or not that study has gained any political acceptance in the legislature or in the criminal justice system as to the importance of keeping caseloads at a reasonable level, and whether or not there's buy-in from, I know the prosecutors have been objecting to you, but what's the level of buy-in to that case weighting study in the system itself?
Yeah, thank you for that question. Just for everyone's benefit, a couple of years ago, the ABA sponsored a caseload study in Missouri called the Missouri Project, where they hired an accounting firm, Reuben Brown, to look at our data. As a public defender system, we don't do well in the political game, and so we got to do it a little bit better than everyone. We got to do a little bit better than everyone else. And so Missouri became the first public defender system in the country, statewide system in the country, to require its lawyers to time log in 5-minute increments, which didn't go over very well, as you might imagine, with the attorneys who are already overburdened. But we told them that this was the path, is to, look, if you have data, you got to study your data. You got to collect it, and then you got to study it. And we needed to make an evidence-based argument to get funding. It's not enough for us to go to legislative office saying we have too many cases and not enough lawyers. And so Reuben Brown conducted a study. They looked at 20 weeks of our data, and they juxtaposed how much time we were spending on every task in every case type. So how much time we were spending research, attending court, travel, motion practice, meeting with clients, and then compared it to how much time private lawyers were spending for the exact same thing. And then through a business model process, they got rid of the outliers and honed in on task thresholds, how much time we should be spending on each task for each case type. And when you do the compilation, based on the number of cases that we have, between 74,000 and 82,000, the types of those cases, our current resources, meaning our current number of attorneys, it yielded what we needed according to this accounting firm. And the result was, based on, in 2014, the number of cases we had, in order to be constitutionally effective, we needed 290 additional attorneys. So picture us going to the legislature with, we need 290 new attorneys. You know, it didn't get us very far with majority of them, but to answer your question, the chair of the judiciary, who's now was just running for attorney general, it carried a lot of weight with him. Now, what was motivating him was he was fearful of some sort of class action where offenders would just walk out of prison because we had this data. Well, I don't care what's motivating him as long as he comes to the table. And he provided $3.5 million. So did that caseload study result in new money? Yes, it did. The governor never let us have it. He withheld the funding, but it nonetheless took a very fiscally conservative legislature and it would made a convincing data-driven argument. So the governor withheld the money, and then 2 years later, the legislature came back again and gave us $4.5 million, which again the governor withheld. But yes, for those states that are interested in doing caseload studies, absolutely, you need to do it better than everyone else. You need to do it better than the Parks Department, Health Department, Education, because no one ever got elected on helping the public defender system. So you need to walk into their offices with a data-driven study, and I would encourage you to do that. And I don't think the attorneys in our system regret having to time log, but they need to see some results, and they need to see some relief soon.
Hello, my name's Doug Colbert. I'm a law professor at the University of Maryland School of Law. And I too, Michael, want to express our thanks to you for taking such a terrific stand and bringing attention to a disastrous situation, not only in Missouri, but really in most parts of the country. I just wanted for a moment just to share and ask you a question about whether the Maryland approach that I was a part of might work in other places as well. The Maryland Defender and Paul's lawyers certainly do a terrific job, but also are tremendously underfunded, and it doesn't look like they're ever going to get any significantly more money. We all knew for many years that people didn't have lawyers at the beginning of the case, except in 1 or 2 counties. And so what we reached out to change the dynamic was the biggest law firm in our state. And we worked, my students and I worked with these 2 excellent pro bono lawyers from the Venable Law Firm, both partners. And for 7 years, we filed a class action lawsuit for the right to counsel at first appearance, and eventually succeeded. Our highest court ruled now that poor people do have a constitutional right to a lawyer at first appearance. There are still problems, of course, but the idea was that when we brought in the private bar and we brought in lawyers who have, by reputation, something very different than a law school clinic or the public defenders, it really elevated the issue and gave attention to lots of people who had no idea, even lawyers had no idea, that poor people were unrepresented for such a long time in the courtroom. And so I wondered whether, you know, it's almost like the 5-year-old boy who finally had the courage to say that the emperor's naked and everyone else would remain silent. I just wonder what would happen if we all looked to private bar lawyers to join with public defenders to really challenge the system, because you can't really say we have a justice system when poor people have to wait sometimes weeks and even months before they're finding a lawyer standing next to them.
Yes, I couldn't agree with you more. You're talking about thinking outside of the box and looking at non-traditional means to bring attention to the matter. And I can tell you that the beginning of this Reuben Brown study that we're talking about was brought by our chair of our Public Defender Commission, our prior chair, while he was president of the state bar. We all know that the measure of any state bar is the type of justice that the least among us receive. And so our state bar felt very convicted, and they championed this study. And in fact, when I needed to get over the hump with some new funding this year in the legislature, I didn't just go to the Office of Legislators. I went to visit managing partners in St. Louis and Kansas City, and they picked up the phone on our behalf because they knew that statute that I have that said, look, if we don't have the funding, I'm going to start appointing lawyers. And at $500 an hour, they'd rather us get the funding. So yeah, we did those things. We need to do more of those types of things. But Professor, I couldn't agree with you more.
Could I just add a piece there about counsel at first appearance, counsel at arraignment and bail hearings? You can't say it any better than Deputy Attorney General Yates said it this morning. It's just, yes, the Supreme Court hasn't yet made it explicit, but nobody can dispute the unfairness of an individual going up against the power of the state with his or her liberty on the line and not have counsel. That's un-American. It's unacceptable. And I was just so pleased to hear the keynote address that squarely. And it's something we all have to get after, and we all have to, utilize our whole universe of support, state bar associations, civil liberties, chief defender associations,
Judges.
law enforcement officials who care about fundamental fairness. All of that has to come into play.
And I'm getting a signal that we have time for one last question.
Hi, my name is Betty Moore. I am a judge out of Memphis, Tennessee, and I want to thank the panel and the Right to Counsel, all those that are putting this together. It's definitely much needed. My question has to do with not only the jurisdictions that have instituted their right to counsel programs, public defender programs. But I'm really curious as to what other specific reasons have been involved with those who give so much pushback. Utah, Idaho, and especially New York, that pushback, so to speak, until the day of trial before they said, okay, we'll do what needs to be done. I know money is a huge issue, but surely there are more issues and reasons why jurisdictions say no.
I think that's an excellent point. I mean, money is always at the forefront of these discussions, and fundamental change is hard. And that's what we're on the cusp of in New York. I hope the next few months will see us getting there. I do like to remind people that when you get to the area of fundamental change, if you can get there, we got there in Massachusetts, then comes the annual I always call it 24/7, 365 struggle for adequate funding to fund the good structure and the good standards that you've put in place. It's you know, I want to be measured in this because for the policymakers, for the public officials who have to make these decisions, they're not as simple or as easy as they are to us who are advocates. And so one of the things we can do as advocates is to assure by our performance to those policymakers that the public funds that they have the political courage to entrust to these reforms will be spent with expertise, with efficiency, and with responsibility.
Yeah, I just want to add to that. I think there are two, I agree with that, Bill, and it was really well said. I think there are also two factors that historically have stood in the way of reform that are changing, and that make me very optimistic about the future. One is that, as a lawyer, if the threat of litigation was brought to a state or a locality over the state of their public defense system, until very recently, and even now to some extent, there was uncertainty in the law over what their legal liability was. So a governor's council or a city attorney or a county attorney could look at politicians and say, I can defend this lawsuit. I think there's an argument maybe that the Sixth Amendment doesn't mean what those people are saying it means. And whether it's the right to counsel at arraignment or the question of pre-conviction enforcement for systemic relief under the Sixth Amendment. One of the things that the Department of Justice is working hard on, and many of you are working hard on, is establishing that the law is clearly established in those areas, and that is happening every day in courts across America, and I think that is now a trend that will continue. The second thing that's changing is that this community of people, and many of the people in this room are responsible for this, have become so much more sophisticated about data and about using data. And with the funding of the federal government, with funding from many of the institutions represented in this room, with the leadership and expertise of people like Andy Davies in Bill's office, who's amazing on these issues, and David Carroll, and NLADA, and NACDL, and all of these groups, we are getting better at using data to show what Bill was saying, that we can first assess systems, like was said on the first panel this morning, and show where the problems are, so that this isn't just some phantom thing or someone just complaining and trying to get more money for something, or that this is a real problem, and that we know that there are real solutions through things like these caseload studies that have been done in all these places. So I think there's a lot of reasons to be optimistic that the obstacles that have stood in the way of real reform in the past are falling to the wayside, and that things will start to get better as we all come together for solutions.
And that's going to have to be the last word on that, so thank you.
I want to thank David and Colette for organizing two terrific panels, and all of the panelists for really inspiring and interesting comments about what is going on in their communities. So thank you all. And I'm going to invite our lightning round panelists to now join us. And while they are walking up here, let me tell you about our next session. This is a lightning round session where we have asked thought leaders and innovators to provide ideas on prospective ways that consortium members can improve our nation's public defense delivery systems, including who might be and how to engage unlikely allies and how we can all be agents for change. This is really the first part of our look prospectively. After lunch, we are going to be turning to all of you to really get to work to think through some specific plans. I'm going to introduce all of the lightning round participants, and they will then proceed to share with you some short remarks. Our first speaker is Joanne Wallace. She is the president and CEO of the National Legal Aid and Defender Association, the oldest and largest national membership organization devoting its resources to equal justice. After Joanne, we'll have Mark Levin. Mark is the director of the Center for Effective Justice at the Texas Public Policy Foundation, the state's free market think tank. Mark also serves as the policy director of the foundation's Right on Crime initiative. After Mark, Judge Bernice Donald, a judge on the United States Court of Appeals for the Sixth Circuit. She was nominated by President Obama and was confirmed by the Senate in 2011. It would be nice if the president could confirm as well. Prior to that, Judge Donald sat on the U.S. District Court for the Western District of Tennessee. In addition to her many other activities, Judge Donald currently serves as the Secretary of the American Bar Association and is the past president of the National Association of Women Judges. Next, we will have John Wetzel, who is the Secretary of the Pennsylvania Department of Corrections. With over 26 years of experience in the field, Secretary Wetzel is widely recognized as one of the country's thought leaders in corrections today. And finally, we will hear from Ivan Dominguez. Ivan is the Director of Public Affairs and Communications for the National Association of Criminal Defense Lawyers. He brings the association's activities and positions to the attention of the news media and the public and maintains ongoing relationships with key legal affairs, justice, congressional, and Supreme Court reporters. He also edits NACDL's daily criminal justice briefing and hosts its podcast series, The Criminal Docket. Joanne.
Thank you, Lisa. Good morning. I think it's still morning. It's really great to stand before you today at the second Right to Counsel convening in this great hall of justice. I can't think of a more symbolic room or appropriate location than this ceremonial location to work on the right to counsel. I want to begin by thanking the Department of Justice, and particularly Attorney General Lynch and her predecessor, Attorney General Holder, for recognizing that it is appropriate for our country's top leaders to include the improvement of public defense as a significant part of achieving the department's mission to ensure the fair and impartial administration of justice for all Americans. We cannot applaud enough their commitment to making real the fundamental promise in our democracy of justice for all. But while it is the case that effective leadership at the very top is essential, it has also been the collective efforts of a cadre of passionate strategic leaders in this Justice Department that has made the significant progress toward achieving equal justice that we have seen and heard. So I just want to take a moment to direct your attention to the table up front, to the names on your agenda, both in this morning and this afternoon, and to just recognize the amazing leadership in this Justice Department and with us here today who have been committed and working tirelessly on this issue, and to say thank you while we have an opportunity before the administration's change. So thank you. But we're here, however, because this promise is broken too frequently. As we've heard and we all know, there are far too many people who end up with convictions and who serve time for offenses without the advice of counsel at all or without appropriate legal representation. But as you've also heard, we have made considerable progress in this century. And I, for one, am excited about where we're going. In fact, Corey couldn't have set me up more beautifully in saying she is optimistic and in talking about the progress we've made in terms of using research and data. I am excited that we are launching the second year of the Right to Counsel Consortium in the Great Hall of Justice. And I'm excited that defenders and the assignment of counsel are an integral part of the MacArthur Foundation Safety and Justice Challenge, as you will hear from Lori Garduque over lunch. And I'm excited that we are in a technology-driven information age that is propelling us to rely increasingly on more and better data, research, science, and evidence. For those of you who are public defenders, were or are, experientially and anecdotally, we know that effective public defense reduces unnecessary incarceration, which in turn lessens the loss of jobs, homes, and other life-altering consequences. Effective public defense services are a core component of public confidence in the fairness of our justice systems. It decreases racial disparities and saves taxpayer dollars. And it contributes to public safety while playing a role in reducing crime. It was alluded to earlier, and I'll say it again. Yes, public defense, effective public defense, reduces crime. But today, experience and stories are not enough to make the case for quality representation. The technology and data revolution are compelling us to rely on empirical evidence for planning, managing, communicating, and advocating effectively to funders and other policymakers, the public, and the press. More than ever, it's imperative to have accurate, verifiable, objective data so that decision makers are not left to form policy based solely on anecdotes and public attitudes are not formed based solely on speculation, intuition, presumption, or bias. Organizations have to be able to measure client outcomes and assess system performance, to define what effective defense is, and to make convincing arguments about the need and allocation of resources. We have to have data to uncover and correct racial disparities. And we are expected to produce research and data to qualify the social and economic benefits that having a quality indigent defense system generates for clients, the criminal justice system, and the community. And this is okay. While much, much more research is needed in this arena, the mounting evidence is confirming the important role that effective public defense plays in the success of criminal justice reforms as we work to build better justice systems. For instance, research has demonstrated an almost threefold increase in the number of individuals released on recognizance when individuals are represented by counsel at initial hearings, as you've heard, and the author is in the room. And we are beginning to see evidence that is quantifying the cost savings as well. Research on public attitudes toward public defense demonstrates that a majority of Americans view the right to counsel as critical to the fairness of the criminal justice system. And a study by the National Center for State Courts reported that additional spending on public defense was among the top 3 items on which individuals believe that the court should be spending taxpayer dollars. Moreover, as you heard earlier, the growing body of research in the area of procedural justice tells us the inescapable conclusion that effective public defense is crucial to building public trust and confidence in the justice system. The Bureau of Justice Assistance SMART approach to improving the justice system using data, evidence, and research to create strategies and interventions that are effective and economical exemplifies initiatives that are ushering in a new future. As the TA provider for Smart Defense, the newest addition to the SMART suite, we are already seeing promising results. Fueled by the first Smart Defense Summit, the knowledge, capacity, and excitement about using evidence-based approaches to drive change and innovation is growing as the teams share information and learn to work effectively across practitioner-researcher boundaries. So you've heard the list of Smart Defense jurisdictions from Director Denise O'Donnell, so I won't repeat that, except to point out that in addition to the work and the effort that is happening on the ground in those jurisdictions, each of the sites are producing research, resources, and results that can be utilized in other jurisdictions across the country. So for example, the Alameda experience will create a playbook for other jurisdictions to follow, including making the case for early entry of counsel through credible research and data, as well as demonstrating the importance of collaboration among criminal justice system players in achieving the ultimate goals of system reform. So, numbers will never tell the whole story. Quantifying the harm suffered by a child whose father or mother is detained unnecessarily in jail without counsel will never be the same as determining the cost savings from an empty jail bed. But through initiatives like Smart Defense or the NLADA Defender Research Consortium and many others that are being initiated by individuals in this room and across the country, we are able to see the significant difference that credible data can make when they are communicated effectively as part of the story and relied on appropriately to guide change. As a strategic ally for the MacArthur Foundation's Safety and Justice Challenge, NLADA is working to elevate the voice of defender leaders and to educate the field about the critical role that public defense is making in reducing incarceration and racial disparities. But as we've also seen, defenders alone can't be the only ones telling that story or leading the charge to fulfill Gideon's promise, which is where this consortium comes in. We need each of you to carry the message and work on the ground where innovation and change take hold. In 2017, NLADA will have the pleasure of working with the National Association of Counties and the National Association of Court Management, both consortium members, to host roundtables on public defense. And we look forward to working with the partners here and those who couldn't be here, and those who will be here next year, like members of the private bar. So, with your partnership and continued leadership from the Department of Justice to help us fill those research gaps that exist, I am confident and optimistic that we will complete the journey to justice for all. Thank you.
Well, thank you very much. It's great to be here. And as you know, I'm with the Texas Public Policy Foundation, a free market think tank, and we started Right on Crime back in 2010, our National Criminal Justice Reform Project. And I can tell you, being from kind of the conservative free market side of the spectrum, we wholeheartedly endorse the idea that people who have more resources can afford to buy, of course, a nicer car. They can have a Tesla instead of a Toyota. But when it comes to indigent defense, and liberty and justice, it should be blind to what a person can afford. Everyone should be entitled to quality representation. And perhaps the only good thing about this election is we have two presidential candidates who know firsthand the importance of quality representation. But it was a very serious matter, and that's why I'm so glad in Texas we have the Texas Indigent Defense Commission. Jim Bethke is here today, who has done an amazing job with that, moving our state forward. And we've heard some of the other states who I think have seen Texas as a model for the need for statewide resources and coordination to ensure this isn't random based on what county you're in. And I think just to highlight some of the challenges we found in Texas, first of all, has been mentioned earlier, so many cases where you have jailable misdemeanors. A Class A misdemeanor in Texas is up to a year in jail. The person actually doesn't get appointed counsel. A variety of excuses are made up and ways judges look to avoid doing that. So for example, in Amarillo, a study was done, 57% of jailable misdemeanors did not get appointed counsel. And unsurprisingly, of course, 87% of those who did not get counsel ended up going to jail. And these were for, marijuana was the most common, first-time DWI, whereas 59% with hired counsel did not go to jail. Huge difference, and the study documented the enormous cost associated with that, both with pretrial and then actual time served. Then, of course, this isn't just Texas. In Pennsylvania, a study found from the Sixth Amendment Center, 37% jailable misdemeanors did not get counsel. So then, of course, we look at what happens when someone does get counsel, but it's woefully inadequate. Harris County, which of course is Houston, has had tremendous problems. The Texas Defense Commission just put out an audit this month on what's going on in Houston. And so we have heard so many anecdotes of counsel being appointed at 9 a.m., pleading out that case at 11 a.m., obviously without any sort of investigation. And by the way, this is really, along with the over-incarceration of pretrial defendants in Harris County, led to the identification about a year ago of several hundred people who had served time in the Harris County jail. They pled to time served just to get out, and then the substance, they were there for possession, the substance, the test came back a year or two later, and it turned out it wasn't even illegal drugs. So they've been going back and trying to fix these cases. These people, frankly, who plead to something they didn't commit, both because they couldn't afford bail and they did not have quality representation. This audit that was just done in October in Harris County found 40% of juveniles did not get counsel within the time period required under state law. Only 59% got counsel within 5 days of the filing of the petition against those juveniles. Now, excessive caseloads are an enormous problem. It was found in Harris County from this audit that half the attorneys had excessive caseloads. One attorney had a caseload of 969 clients. It's just astonishing. So there's some real good news, though, and let me say, I think, first of all, we've got to look at police diversion, the LEAD program in Seattle, which is now being done in North Carolina, and also converting some of our criminal offenses to civil infractions so that we take the number of cases down where counsel is required, and that will help us focus limited resources more effectively. Of course, also there's examples around the country like Seattle and Miami where they have rapid appointment of counsel, typically at first appearance in most cases. Even in Texas now, Bexar County has implemented counsel at first appearance for those with mental health problems, and Harris County is committed to doing that as part of the MacArthur grant, the MacArthur Challenge, which they're participating in. So there are a lot of things to be pleased about. One of the most innovative examples actually is in Texas, in Comal County, which is a county of about 120,000 people outside of San Antonio, but they've implemented a managed choice program where defendants can choose among a list of 30 to 50 qualified attorneys whose caseloads are monitored by the county, but this isn't under the elected judges, this is through the county itself. So again, we have more fidelity to the client and independence from the judiciary, because too often the judges just want to move their dockets and want the lawyer will be the least. So we're waiting from the Justice Management Institute, was commissioned by the Texas Indigent Defense Commission to do a study on how this is working, but we do know that 75 to 80% of clients have opted into the system to choose their attorney instead of having one assigned by the judge. So that's quite encouraging. I think as you look towards the future, you could see, for example, now it's mostly word of mouth, but you could see, for example, something like Angie's List or even the Uber rating of your driver, so you could see how other defendants defendants evaluated that counsel. So to me, that's very exciting. Obviously, there's a number of jurisdictions that go with more of the public defender model, and I think you can do either of them well. But in either case, you can't obscure the fact you need sufficient resources. And in Texas, most of the time, these appointed counsel, or in the case here, the chosen counsel, they're paid a set fee. And so you do need to make sure that's adequate, that defense counsel have access to experts, forensic testing, and things as we've heard earlier. So I wanted to just also touch on a couple of the needs going forward, some of the key issues, in addition to kind of the core responsibilities of indigent counsel, and then I'll conclude. But first of all is kind of working with prosecutors and judges on risk needs assessments, and I think it's a very difficult challenge. Obviously, we have to make sure that there's proper training, so that just because somebody scores medium or even on the higher side doesn't necessarily need to mean they need to be incarcerated. The needs point, the needs half of it is equally, if not more important than the risk part, and by, of course, having an intervention that addresses those needs, many individuals who aren't low risk can still be supervised in the community. Obviously, these assessments need to be validated on the specific populations. I recommend excluding things like drug possession, which we know have a disparate impact because, of course, individuals who are from areas where there's more police are more likely to be arrested for marijuana than someone who doesn't live in those areas, and that ends up having a racial impact. So, and also, of course, not including arrests, but only convictions. So the Arnold Foundation has done a very good assessment, I think, that is one that can be done even without an interview for pretrial, but there's also assessments for after that process. But I think a number of jurisdictions, like San Diego, are looking at how can prosecutors look at this assessment even before offering a plea, so the whole system is informed much earlier in the process. But again, the defense counsel has to be very much involved in this, and we have to make sure that it's not used to increase somebody's penalty. Now, the other issue is, I think, involving appointed counsel, or however the counsel is, whether it's appointed or a public defender, in collateral consequences, including record sealing and also issues of asset forfeiture. Because what you'll find is someone who may have perfectly good counsel, who is provided by the government, then when the case also involves forfeiture, because that's a civil issue, or then they may be entitled to record sealing, they don't get any help when it comes to that. And so they are unable to take advantage of something that someone with resources would be able to. So I think those are very important as we move forward. So we are really optimistic with the progress we're seeing across the country on this, but there's, as has been said before, there's a long way to go, and I think we certainly shouldn't rest until everyone has quality representation.
Louder. Thank you. I'm Judge Bernice Donald. I am a Southerner. I do not speak as rapidly as my colleague from Texas. We have limited time. If I had more time, I would thank you properly for the opportunity to be here and participate in this Right to Counsel forum. But time is very limited. The Sixth Amendment, Norm Reimer said yesterday, is an orphan amendment. It doesn't apparently enjoy in the public province the same status as its sister and brother amendments. And I believe that the conversation today enlightens us on some of the things that we need to do to make certain that people who are poor and who cannot afford counsel have their rights safeguarded. So what are some of the things we can do, and what are some of the problems? I think the problems have been amply laid out earlier in the day, but let me mention one that we haven't talked much about, and that is public perception. The reality is that the public perception of people who need counsel and can't afford it is that they're not deserving. They are simply not deserving. They did it, they need to face the consequences, And there's really not a lot of commitment to providing those resources to those individuals. Where do they get those ideas? I think that we no longer talk about the concept of innocent until proven guilty. That's been turned on its head largely. And if we look at popular TV, for example, it's been a long time since Atticus Finch, but we have had many programs day in and day out where people form their opinions about the justice system. They know the role of the police. They've known that for a long time. They watched the streets of San Francisco. They watched NYPD Blue. They now watch Blue Bloods. They know about that. And when it comes to the role of the prosecution, they know that also. They know about law and order, and they know what happens in those venues, and they know how it's supposed to go. They know about the judge shows, so they know about the role of the judges. But where is it in popular media that they see the role, the responsibility, the merits of the public defender? It's not there. Now, I'm not up here advocating for a TV show about public defenders, but we do need to recognize that that's a necessary component of the justice system. So, what are some of the things that we need to do today? And I want to stop and digress just a moment and tell you that when I was a trial judge in the federal system for 15 and a half years in criminal trials, I would start out by asking the prospective jurors, does anybody believe that just because that person is sitting here required to answer these charges, that they must be guilty? I can't tell you how many times the majority of the hands went up. There's a lack of understanding, really, about the roles and responsibilities of those individuals in the justice system. And we need to do a better job of educating everyone about those roles and responsibilities. We're all stakeholders. And we've heard a lot about money, and I think it's a real issue. But money is really assigned according to priorities. And apparently, as we've heard this morning, the public defender assistance programs have a very low priority. Brian Stevenson of the Equal Justice Institute says repeatedly, and I concur in this, that in these United States, it is better to be rich and guilty than poor and innocent. And that's an indictment, again, against us and our system. What are some of the things we can do in my 5 minutes remaining? Well, some of the suggestions or some of the measures that could be taken. At the federal government level, the United States should provide ongoing support and oversight to ensure that states fully appreciate the federal constitutional right to counsel for criminally accused persons who cannot afford to hire counsel. Congress ought grant the DOJ the authority to enforce the Sixth Amendment right to counsel. We have wonderful, strong laws, but we need to remember that laws are not self-executing. They are not. We need to list public defense as a permanent line item in the annual budget. We need to prioritize improving state and local defense delivery systems. The Department of Justice can file amicus briefs supporting the safeguarding of the right to counsel, and they can continue to file those statements of interest. The department can fund creative public defense demonstration projects. They can further fund training for state public defense and criminal justice systems and other criminal justice stakeholders. They can conduct investigations into the no counsel court convictions to investigate the extent to which defendants are convicted without access to counsel and the mechanisms that allow this deprivation to take place in the first instance. At the state level, and I was a county court judge for a period of time in my life, state policymakers should ensure adequate funding and oversight for public defense services. State Supreme Courts can take the lead on right to counsel reform by adopting court rules. They can adopt mechanisms for evaluating attorney performance. They can get involved in the provision and the mandating of more training, supervision, and look at making certain that eligible populations receive the services that they rightly deserve. And we cannot let state legislators off the hook. They have a critical role to play in this process and must play that role. And state and local bar associations must be involved in the advocacy to ensure that state legislatures embrace their responsibility to the total system. And for all of us who have a stake in protecting and maintaining the right to counsel, we must ensure that public defense is represented in all criminal justice meetings, that we get involved in helping to shape a national strategy that advocates can embrace in modifying some of the effective assistance standards that are enunciated in Strickland v. Washington. And we must support opportunities for law students and clinics to get involved in helping in this role. I hope that out of this meeting that we will have not only meaningful resolutions and meaningful ideas of reform, but we will come out with a commitment to also educate the public in this whole process, because they simply don't understand, and if it's not before them, and if we don't put it before them, they simply don't know. And we cannot leave the responsibility to just the people who are out performing public defender services. All of us have a stake in this, and we must embrace our obligation to safeguard and fully implement and execute Sixth Amendment rights. Thank you.
Well, good afternoon, everybody, and thank you so much for inviting me here. If you would have told me 2 years ago that I would be sitting at this consortium, I would have not believed you at all. My name is John Wetzel. I'm the Secretary of Corrections for the state of Pennsylvania. We have the 6th largest prison system in the country. And I inherited a system almost 6 years ago that was growing by 1,500 inmates a year. We were literally adding a prison every 18 months at a cost of about $200 million. I'm happy to say that since that time, we've gone through a series of corrections reform, largely driven by, and I see my friend Denise O'Donnell in the room, largely driven by justice reinvestment, where we've really tried to make better decisions in our system. And I've been fortunate to be the beneficiary of a lot of reforms. And I say that to you because it's actually an embarrassment that up until recently, I really didn't see a connection to indigent defense and what I do at the back end of the system. But if you want to look for the strongest argument for making significant improvements in the front end of our system, just look at the back end of our system. The back end of our system tells a story that none of us should be proud of. Disproportionately incarcerates poor people, people of color, and people with behavioral health issues, especially mental illness. And that's not okay, and we shouldn't be okay with that. And in many ways, the guardian to that is indigent defense. Yet in Pennsylvania, and you heard earlier that Pennsylvania is, I guess, now one of 2 states that has 0 state funding for indigent defense, in spite of the fact that beyond all doubt, we have a vested interest in decisions made on the front end of the system. We, from a policy standpoint, haven't been able to make the nexus between making real investments and the vested interest we truly have. And I know in the political environment, the reality is long-term thinking is the next election. And so for more than half the people in Harrisburg, which is our state capital, it's every 2 years. That's not the rubric under which we're going to make great decisions. But the reality is we need to, because it's not just a financial cost, but the cost goes well beyond it. The 50,000 inmates I have in my system today have 81,000 children who are impacted by our terrible decisions we make at the front end of the system. And when you look at the 2 key components of the front of the system, and that's how we make bail decisions and proper defense, it's an embarrassment. And I'll talk about Pennsylvania, but I don't think Pennsylvania is a super outlier in most of this. And number one, to get the attention of policymakers and politicians to see what the importance of it is a significant challenge. And I was really excited to hear some of the work that Missouri's doing in making a return on investment argument. Because you heard earlier, there was just a state Supreme Court case in Pennsylvania that gave defendants standing to sue counties who fund indigent defense for inadequate defense. And you would think, and I've heard a lot of people really trumpeting that as this great thing, and you would think that that had a political implication in Pennsylvania. I got to tell you, it didn't. It literally moved the needle not at all from a political standpoint. Not one bill has been introduced to address it, nothing. And in some ways, maybe that's a value statement. In other ways, I think it's incumbent upon us, if we want to move the needle, to figure out how to make the value statement to move the needle on this. I think the second and related thing is that when we get these disparate outcomes at the back of our system, it's really incumbent upon us to look at the front end of the system. And it doesn't matter what room we're in, I think we can agree on what we want out of our criminal justice system. That when someone becomes criminally involved, at the back end of the system, we want them less likely to commit a crime. The path to do that, though, requires us to, first of all, make a good decision at the front end. We know that when lower risk individuals come into jails, they come out more likely to commit a crime. That's inconsistent with what we're trying to achieve. But if we don't put mechanisms in the front of the system where, first of all, we can truly assess the risk, and second of all, truly understand what the root cause of the crime and find a way to put the individual on the path to mitigate that risk, then what are we doing? Why are we wasting the amount of money we're wasting? The beautiful part of criminal justice is that when we make better decisions, we use the system with precision. And when we use the system with precision, it costs us less. So it continues to baffle me why we don't find mechanisms to make better decisions. And all we have to do is look to the medical field. If you look at the medical field, if I would have blown my knee out 20 years ago, I'd have a big scar up my leg. If I do it today, I have 3 little holes. Same healing, right? But less damage. Can't we use that same picture? How can we do the same healing? How can we put an individual on a path to be less likely to commit a crime, but do it with less damage? We have to make that first decision with precision and with data and the data that's available. And in Pennsylvania, like many systems, we have over 400 magisterial district judges who simply have to get elected, similar to some other states, who make this decision. And I don't even call it a bail system because it's not systemic. The only thing that's systemic is that we make bad decisions, and those bad decisions have implications. Those implications are increased crime and more people in human services and more kids in foster care and more expenditure that we need less. But I really believe that the path to this is unlikely partners. And I think when you're trying to move criminal justice policy, it's very easy for us to go to anecdotes. And if something bad happens to Fluffy, we're going to pass Fluffy's law tomorrow and lock people who abuse Fluffy up for longer, right? In spite of the fact that that may not have any real practical implications in addressing the problem. So for us to get to a place, we have to cobble together enough votes to change things. And that requires unique partnership. So I'm really excited to have been able to spend some time here, and also would encourage you in all your states to connect with your corrections director. We too have an association, the Association of State Correctional Administrators, who really spend a lot of time in thoughtful conversations very similar to you're having. We all have a responsibility. We want our criminal justice system to be just. We can't do that without a strong front end, coupled with a strong back end, and that partnership is just a natural partnership. So I would strongly encourage you to look for unusual partners like corrections directors, and understand that the constitutional issue is compelling, but it has not moved the needle to this point. And I hate to say that in a room, especially a room like this, but that's the reality of the halls that I travel in. And so I think it's really important that we focus on return on investment, on outcomes, on really quantifying the impact of our terrible decision-making at the front of the system, and make the argument that we can make better decisions, have better outcomes, and invest that money back where it should be, which is in the communities and the schools and all that stuff that keep people from committing crime in the first place. So thank you very much, and thanks for your time.
Hello. My name is Ivan Dominguez, and I'm the Director of Public Affairs and Communications at the National Association of Criminal Defense Lawyers. And today, I get to be that speaker between you and lunch. So I will try and make this as interesting as possible. Nearly 9 years ago, I left the corporate world and came down, moved to Washington, D.C. to work for NACDL. And each day I get to live a directive I was taught from when I was a young kid, something I think many of us will agree with, which is that if you save a single life, it's as if you've saved the world. And you hear a lot of people today talking about part of saving these lives and saving these communities is legislation, it's litigation, it's lobbying, it's individual representations, it's impact litigation. Well, it's also, as Judge Bernice Donald said, about educating the public. And all of these things involve effective messaging and effective communication. And one very important part of the Right to Counsel campaign is the communications peg. We've left that slide up during this entire lightning round, hoping that you make a note of it. At the end of my short presentation, I'll tell you the one thing you need to take away from anything that I've said here right now, and if you do that, it will have been a complete success. You look around the room at how many people are here. There's also a camera in the back. All of this is being live streamed on the internet. Within days, we'll be sending out video of this on Twitter, on Facebook, in the Right to Counsel newsletter, posting it on the website for Right to Counsel. It's a tremendous honor, myself and my incredible colleague, Ezra Dunkel-Polier, who is NACDL's Public Affairs and Communications Assistant, have the honor of curating the Right to Counsel website, of managing the social media communications, of putting together the monthly newsletter for this important campaign that's just now finishing its first year. And in that regard, we need your help. When you see an interesting story, when you write an interesting story, when an important report comes out, send that to us. Ezra and myself, our email addresses are in your monthly newsletter that you all receive. Post them on your own social media accounts. Use the hashtag #2counsel. That's the one thing I was going to tell you at the end. If you don't remember anything else, use the hashtag #2counsel for everything related that you post to the internet. But what we're doing on the website is also something very, very important that is a tremendous resource that I commend you to exploit to its fullest and to participate in building. We are building a library. We are building a library of resources that points to many of the organizations that are in this room, represented in this room, reports, white papers, articles, publications, databases. We're aggregating all of that on the Right to Counsel's website, rtcnationalcampaign.org. And this is because, and again, Judge Bernice Donald, quoted Norman Reamer, our executive director, and I hear his voice in my head right now. One of the things that Norman has said to me repeatedly, and one of the things that we need to accomplish with this campaign, is to get the public, to get people to be as invested in the Sixth Amendment and their rights in the Sixth Amendment as they are in their rights in the First Amendment, or their rights as they understand them in the Second Amendment, or any other amendment in the Constitution. We need people to get that connection. Regular people, people who are not lawyers, lay people, people who watch television, watch films, just live their lives, need to understand that a critical part of the American experiment, a critical part of our constitutional order, is this Sixth Amendment right to counsel and everything that it represents. And I don't need to go over all of those things because you've heard people talking about that all morning, and you've heard people, you will hear people speaking about that throughout the day. But we want you to send in resources. We want you to submit blogs for us to disseminate. We want to be facilitators for you to get your voice heard in the larger context. I mean, community now really is very much online, and so it's important that we have our voices out there, and we can magnify and multiply the effect of what we're doing with your help. And for those old enough to remember that commercial from the 1970s, if all of you tell two friends and they tell two friends, we will get there. But we need to do it in a way that people understand, that people find interesting, and that effectively get people to embrace what is theirs, and that is their Sixth Amendment right to counsel. So there you have the social media and website information, and please hashtag right2counsel. Thank you.
I want to thank all of our lightning round panelists for really short, as they were instructed, but really inspiring and important comments. So thank you all. Judge Donald talked about the need for a media presence for defenders. Well, we have with us today someone who became an accidental but nonetheless impactful media hero as a public defender. Toussaint Romaine is a public defender in Charlotte, North Carolina. Many of you may have seen him on CNN and on various media outlets throughout the country. When there were protests in Charlotte, he did what I suspect many public defenders do. He took to the streets and walked with people and tried to maintain the peace between law enforcement and the protesters, and did it successfully. What he did from a media perspective is not just be a public defender, but he reminded people of the important role public defenders play every day in community safety and in keeping their communities calm and safe. And for that, we're pleased to have him with us today. So, Toussaint, I know he's very someplace. And it's lunchtime. Lunch is brought to you today not by the Department of Justice, I hasten to add, but by the NLADA and the School of Public Affairs at AU. Lunch is in the back. We're going to take about 15 minutes to grab your lunch, sit back down, and then we have an interesting lunchtime program for you. Thank you. And we're back. If everyone can take their seats, we're going to start our lunchtime program. And since he was out of the room when I talked about him earlier, Toussaint Romaine, if you'll just stand up so everyone can see you and acknowledge the good work that you did in Charlotte. It is my distinct pleasure to introduce three extraordinary women, and it will, I assure you, be your distinct pleasure to listen to them talk today. Two, Carol Mason and Vanita Gupta, are among my closest colleagues in the department, and one, Lori Garducki, is someone who has made an enormous impact on the work that we all do. I do want to take a moment of personal privilege just to talk briefly about Vanita and Carol. Both of them run components that are large and have a broad mandate. And unlike me, who runs a smaller component with a pretty singular focus on access to justice, but they have been extraordinary partners and really, because they care so much about these issues, have worked across what can often be the silos of a big bureaucracy like the Department of Justice, so that we can all do the work that we have done and we are justifiably, I think, proud of. And without the two of them, none of the work that my office does or the work that the department does would ever be possible. So we are going to start today with Carol Mason. Carol has been the Assistant Attorney General for the Office of Justice Programs since 2013. She oversees an annual budget of more than $2 billion dedicated to supporting state, local, and tribal criminal justice agencies, an array of juvenile justice programs, a wide range of research, evaluation, and statistical efforts, and comprehensive services for crime victims. Prior to taking the helm at OJP, Carol served as a Deputy Associate Attorney General, and prior to her government service, Carol practiced law at the Atlanta law firm of Alston and Bird, where she concentrated on public and project finance. As the head of OJP, Carol plays a unique role in the Justice Department. She gets to put money where her mouth is. And fortunately for all of us, Carol cares deeply about criminal justice reform and about the need to ensure that state and local courts respect the Sixth Amendment. Carol.
Thank you for the introduction, Lisa, but I've got to give credit to the people who really give out the money, and that's Denise and Betsy Griffith, and Priya Sarathi Jones is here somewhere. So they're the ones that really deserve the credit for all of this. I just get to represent them. So it's a pleasure to be here with Lori and Vanita, and to reiterate the points that the Deputy Attorney General made so eloquently this morning. As she made clear, equal justice under the law isn't simply a convenient legal principle. It's the very bedrock of American jurisprudence. I think it's important for everyone who works in this adversarial system to understand that. And we're here not just to win cases, we're here to pursue justice. And I was fortunate enough to moderate a panel yesterday of prosecutors in a program that Cy Vance is funding that's going to help prosecutors across the country. And it would be music to your ears yesterday to hear prosecutors talking about it's not about convictions, it's about justice. It's about keeping people out of the system who don't belong in the system. So if I were you, I'd get a list of everybody that was at that program yesterday and everybody who's on the advisory board for the Institute for Innovation and Prosecution that the new Manhattan DA is funding with its asset forfeiture money, and make sure that you develop these partnerships and look at the materials that they're putting out, because they're talking about different kinds of partnerships and different ways for prosecutors to do their business, and you all ought to be in deep conversation with them about these issues. So I'm proud to be part of a Justice Department that embodies this philosophy, and to have two attorneys general during this administration who have made an active push for better quality legal representation for all Americans. Coming from the nation's leading prosecutors, I think this sends an incredibly powerful message. In his book, Gideon's Trumpet, Anthony Lewis referred to Clarence Earl Gideon as one tossed aside by life. Sadly, many of those who come into contact with our criminal and juvenile justice systems are exactly that. Poor people living lives of hardship and struggle, and when they reach the system, they encounter more of the same. And I will say that thanks to the leadership of Vanita and Lisa, we are, as a department, really working on these issues. We know that this point was made in stark terms by the Justice Department's investigation of the Ferguson Police Department and Municipal Court. The investigation found that the city was relying on the justice system to close budget shortfalls, and poor, mostly African-American citizens were literally paying the price. And Ferguson is not an isolated case. And I need to say that I don't think these jurisdictions were doing it with malintent. They were looking at their resources and thinking, oh, this is a creative way to finance our system. But thanks to the work that Civil Rights Division did in highlighting this issue in Ferguson, and thanks to Lisa's passionate advocacy on this issue, hopefully you're all aware of the work that we've been doing on fees and fines and bail reform, and we're going to count on you to keep that work going. The inability, as you know, to pay these legal obligations and the collateral penalties that go with them drag people deeper into the justice system, and in many cases leave them no way out. This is precisely what's happening to indigent defendants, both adult and youth, when they are denied effective counsel. Their poverty all but assures them of the remaining entangled with the system for years to come. Another digression I want to mention is that Daquan Johnson, the young man in Florida, he presented at a panel at the International Association of Chiefs of Police last week. And I want you to know that these issues are really resonating across the criminal justice system. People are really hearing this and understanding the issues, and I think that you've got some unusual partners that you need to make sure that you follow up with in this work to really see the changes we all want to see made. Due to under-resourced public defense systems and overworked defenders, we have effectively two justice systems, one for the wealthy and another worse one for the poor. The Department of Justice recognizes that this does not conform to the principles of fairness of our legal system. and it does not represent what we aspire to be here in America. You heard Denise O'Donnell talk this morning about the Smart Defense Program that brings together researchers and practitioners, and Gideon's Call, which provides training to defenders and funding aimed at improving caseload management. We're also looking closely at the juvenile justice system, where the crisis of counsel is at least as pronounced as it is in the adult system. Anyone who works with justice-involved youth know that these young people are thrust into a system they don't understand and left to make decisions with little grasp of the consequences. In many cases, they are encouraged, either openly or implicitly, to waive counsel. The Survey of Youth in Residential Placement, which based on self-reports, found that more than half of young people in detention facilities said they did not have counsel represent them. This leads to what the Supreme Court 50 years ago called the worst of both worlds. Neither the legal protection afforded adults nor the care and treatment a young person really needs and deserves. Last year, our Office of Juvenile Justice and Delinquency Prevention launched its Smart on Juvenile Justice initiative to improve access to high-quality legal services for justice-involved youth. 4 states, Delaware, Indiana, Kentucky, and Washington, received grants to develop statewide juvenile defense strategic plans. 2 of these states, Delaware and Indiana, were awarded follow-up grants to implement their plans. The National Juvenile Defender Center is our training and technical assistance provider for this program, and we're working with them to support regional juvenile defender resource centers to provide data, training, case support, and other resources. And this Friday, I'll be at the Center Summit with Broderick Johnson of the White House to talk about what we can do to advance these issues. Our investments extend beyond capacity building. A hallmark of our mission is to lay a foundation of knowledge on which we can build a smarter justice system. Our National Institute of Justice supports research on evidence-based tools, protocols, and policies to help state, local, and tribal systems meet their responsibilities to ensure effective systems. Over the years, NIJ has funded a variety of projects. One was a study by the RAND Corporation that examined the effects of public defender versus court-appointed attorney representation on homicide outcomes. It found lower rates of conviction and shorter sentences when public defenders were on the case. This is critical information in the debate about the role of assigned counsel and the lack of financial incentives for private counsel. NIJ has several ongoing projects that we're excited about. We're conducting a multi-site evaluation of holistic defense programs. We're studying the effects of waivers in juvenile court, and we're looking at how defenders can play a role in reducing racial disparities in felony cases. And hopefully most of you know about the data collection that BJS has undertaken. So our data collection activities are giving us a clearer picture of the state of indigent defense in our country. It's such a disparate system, it's been hard to figure out how to capture what's happening. But next month, BJS will publish data from its National Survey of Indigent Defense Systems. This will tell us about staffing, budget, caseload, and other aspects of state and county systems. Work is also underway to field test an instrument that will capture the experiences of attorneys who represent indigent defendants. So all of these activities are geared towards making sure that we have the information we need to understand where we need to improve our system. As part of that effort, Vanita, Lisa, and I our offices are working together to reduce over-reliance on fees and fines, which I mentioned earlier disproportionately impact the poor. OJP is also supporting reforms to our pretrial system to move away from its focus on money bail, which again penalizes the disadvantaged, and move towards individualized assessments based on risk. We're trying to improve our understanding of the factors that lead to wrongful convictions and working to eliminate those errors as well. We're providing training and tools to help attorneys who represent defendants in capital cases as well. And we're supporting efforts like problem-solving courts and other diversion alternatives that can help address the challenges of mass incarceration and blunt its outsized impact on poor and minority communities. And access to counsel is very much tied to these challenges, and we must address it as part of the larger strategy. We've got a lot of work to do. We've made a lot of progress, but there's so much more to do. Now, I know that many of you all are worried because 3 of us will be leaving our jobs sometime in January. But the key thing is you're not. And your voices are important. And so I'm going to call out some people. So Norm, Joanne, you all demanded things of me, didn't you? You raised your voices. And over the 3 years, they've been relentless in representing your issues. And you'll have to ask them whether they've seen any results of them making those demands. So my point in making this, in telling you this is you've got to continue to raise your voices. It doesn't matter who's in our seats. You know what needs to be done. We've put the infrastructure in place in our offices that will be there when we're gone. Demand continued progress on these issues. So do I have your promise to do that? That's not a real promise. I mean, don't you all care about this issue? Okay, so I'm counting on you all.
Thank you, Carol. Vanita Gupta has served as the head of the Department's Civil Rights Division since 2014. Prior to joining the department, as most of you know, Vanita served as the Deputy Legal Director of the American Civil Liberties Union and the Director of its Center for Justice. And she previously was an attorney for the Racial Justice Program. Over her career, Vanita has earned a reputation for working closely and collaboratively with law enforcement, departments of correction, and across the political spectrum to advance smart policing and criminal justice reforms. Here at DOJ, she has brought that collaborative approach to enforcing our nation's civil rights laws. As you've undoubtedly read or heard, Vanita and the Civil Rights Division have been hard at work on so many critical issues, from policing to language access to disability rights, and fortunately for all of us, particularly on the right to counsel. Vanita?
Thank you all. It's great to see everyone, and I'm always honored to share the stage with Carol and Lisa, whose leadership on these issues, it's not just kind of a professional commitment that they bring to this, but a kind of very strong personal commitment to these issues. And it's so great to hear Carol kind of talk about OJP's amazing work in this space, because the research and evaluation and funding and evidence-based practices that they are helping to support and push out, I think are helping to bring new people into the work that all of you are doing every day, and it's so critically important. I also just want to thank all of you. Many of you are friends that I have been working alongside for many years, and I know Carol called out Norm and Joanne, and there are so many others of you here that are doing this work. This is critically important work. I think that we are at an amazing time in the country with kind of a nationwide conversation about criminal justice reform, about smart criminal justice practices. But often, and probably you feel this as much as any of us do, indigent defense reform is sometimes kind of more of a sideline part of the conversation, and it shouldn't be, because it's so critically attached to the broader issues that all of us are seeking to address to make sure that we have a fair and just criminal justice system to begin with. Throughout the Civil Rights Division's policing work, some of which is a little better known than our work to ensure access to justice, which we do alongside OJP and ATJ. But throughout our policing work, we find, just like our investigation in the Ferguson Police Department and municipal courts found last year, we see how breakdowns in community police trust really often have much broader causes. They have causes where there's more or greater symptoms of distrust in public institutions or even in government itself. And this often happens when people believe that the justice system does not function equally for low-income communities and communities of color as it does for others. But we also know that a justice system that does live up to its ideal of equality under the law, and that's an ideal that requires ensuring that there is a meaningful right to counsel, that courts can actually serve as a check to unconstitutional police practices, that courts can help to restore trust in public institutions. Simply put, I think public trust requires faith in the legitimacy of our justice system. And public trust requires that people believe that our public institutions provide justice and fair treatment. The right to counsel embodies a core truth of our justice system, and it really, to me, makes real the concept of fairness under the law. All of us know all too well the promise of the Gideon versus Wainwright decision, but we also know all too well that for too many people in this country, Gideon is a promise that is unrealized and unfulfilled. In too many communities, indigent defense is in crisis, and the right to counsel is observed in name only. And when defendants lack a meaningful access to counsel early in the process, it perpetuates inequities throughout the justice system. And so many of the problems that we face in the criminalization of poverty, including the harmful and unlawful fines, fees, and bail practices that Carol talked about, really arise when people with limited means are unable to effectively navigate our legal system. There is no mistake to be made that public defenders every day are working tirelessly around the country to vindicate the rights of the most vulnerable and marginalized among us. But we find that due to underfunding and high burdens, they can't perform the core functions of their jobs in too many communities. And the people who suffer are people living in poverty who are coming into contact with our criminal justice system. And so in that regard, our country then falls short of its ideals. Now, the Justice Department is doing what we can, and I think you've heard from Lisa, you've heard from Carol, and you've heard from Denise and the Deputy Attorney General this morning. We are doing what we can to shine a light on the right to counsel crisis that's playing out at the state and local level. And Lisa informs me that some of you also talked about the limitations on the Civil Rights Division's ability to reach some of these issues, but certainly our three components are doing everything we can to use the different tools that we have to raise this issue and to ensure that we can help advance justice the way we can. In courts around the country, from Washington to New York to Pennsylvania to Georgia to Idaho, the Civil Rights Division and Access to Justice have argued that if public defenders can't talk confidentially with their clients, when they can't investigate allegations, when they can't meaningfully test the prosecution's case, that can violate the Sixth Amendment. And you heard probably from my colleague Corey Stoughton talking about her litigation in Hurl Herring, and just taking the story of James Adams, who's one of the plaintiffs from that case. You know, after he allegedly stole sticks of deodorant from a Rite Aid drugstore, police arrested him on charges of felony robbery and burglary, and he faced up to 14 years in prison. And with bail set at $2,500, which he couldn't afford, he sat in jail for more than 3 months. He never saw an attorney outside of open court, and at one of his court appearances, the attorney didn't even bother to attend. According to the complaint, his arrest and incarceration caused him to lose his job. And with no job, of course, Mr. Adams couldn't support his family, and he couldn't pay his rent, and that led to eviction. And we all know these stories. Many of you have these stories among your clients that we know all too well. It took a little while, but just weeks after the Justice Department ultimately filed a statement of interest in that case, New York reached a comprehensive settlement agreement with plaintiffs to implement transformative reforms to its public defense system across 5 counties in the state. And reforms that included guaranteeing that indigent criminal defendants would have legal counsel at arraignments. And it established caseload and workload standards for public defenders to ensure that they can adequately serve each other. And I want to serve each client. I want to point to something that Denise mentioned this morning. I think it's going to be really tremendous when OJP is able to put out the results of the workload study that I know you've been funding for quite some time, because I think that kind of research is really important for the work that we do. In the juvenile justice system as well, from Missouri to Mississippi to Tennessee, we've been working to enforce the rights access to counsel for all children. And far too often, children living in poverty, children with disabilities, children of color are getting stuck in the juvenile justice system and find themselves in a pipeline to prison. In Shelby County, Tennessee, our work led to a transformative settlement agreement and a specialized juvenile defender's office. The office continues to build its capacity. It's still a work in progress, but it's been providing more youth in need with attorneys who have reasonable workloads and effective training, and we've seen the numbers of incarcerated youth go down. In Meridian, Mississippi, our agreement with the city prevents police officers from interviewing detained youth without an attorney or guardian present. It also mandates that officers inform children of their Miranda rights as soon as a youth reasonably believes that he or she cannot leave freely. And our agreement with the State Youth Probation Agency requires that staff notify children of their right to counsel at probation revocation hearings, among other protections. As I mentioned earlier, the challenges that we see in indigent defense, namely that people in poverty lack access to justice, do not result in a vacuum. the constructive and systematic denial of one's Sixth Amendment right to counsel can lead to other practices that criminalize poverty. And earlier this year, as you know, this emanated out of work that not only came out of the Civil Rights Division's Ferguson investigation, but actually out of a lot of research and reporting from many of you in this room about the problems of debtors' prisons and courts around the country. But the Justice Department launched an initiative. It was a kind of a three-component initiative, and we sent a Dear Colleague letter to state and local judges to help them guard against unlawful fines, fees, and bail practices that can result in an inescapable cycle of debt and incarceration. And our letter explained that courts must provide meaningful notice and, in appropriate cases, counsel when enforcing fines and fees. We've also been very active now in talking about bail practices, in filing briefs, arguing that if bail practices result in jailing people because of their poverty without consideration of their ability to pay or alternatives to incarceration, such practices violate the Constitution. So we at the Justice Department, though, are well aware that there's a crisis in the way that people living in poverty actually experience our justice system in too many communities around the country. We are committed to doing what we can to address this crisis. And as Carol said and Lisa said, it isn't just about the three of us here on stage. I work with some of the most incredible lawyers at the division and who are going to be here. They're career attorneys who are deeply committed to the ideals of the work that all of us are doing right now. And they are going to be here carrying on the work. But we also know and we rely on all of you to make sure that we are doing what we can and what we should be doing here at the Justice Department to lift up these issues. We know there's more that we can do, and it was through the advocacy of all of you in this room that we started to look under sofa covers and look at old briefs and figure out where are the paths that we can actually make a difference using the tools that we have at our disposal. And we need you to keep bringing those ideas to us regularly and often. I think all of us in this room know that laws and decisions alone don't vindicate rights. People do, and people like you and all of your colleagues do. People like Clarence Earl Gideon, people living in poverty who are yearning for justice do. And so while we have made a lot of progress, and we should take pride in that over the last several years, really none of us can afford to settle for a justice system that works only for some in our country. And we have to continuously look for unusual allies and bedfellows that we may not know are in our midst to bring them on so that indigent defense reform can always be very squarely a part of a solid criminal justice reform platform. And I'm just looking around this room, I feel optimistic about that, and I just want to thank you all for what you do to ensure equal justice for everyone in this country. Thank you.
Thank you. Lori Garducki is a director at the MacArthur Foundation, which she joined in 1991. Previously, she served as the director of the National Forum on the Future of Children and Families, a joint project of the National Research Council and the Institute of Medicine. From 1984 to 1987, she was the director of governmental and professional liaison for the American Education Research Association here in Washington, and she was a Congressional Science Fellow in the United States Senate. At MacArthur, as I'm sure all of you know, Lori oversees the Foundation's criminal justice and juvenile justice projects, and she has been a true leader in the field. She most recently launched the remarkable Safety and Justice Challenge, which I'm sure she will be talking about today. Lori?
Thank you for that introduction, and a special shout out to all of my colleagues who joined me here and who've been participating in the Safety and Justice Challenge. It's my pleasure to be here. I appreciate the Right to Counsel initiative and the work of the Department of Justice and their partners that have been represented here today. So my charge today is to describe the critical role the Defense Bar plays in the Safety and Justice Challenge, the MacArthur Foundation's initiative to change the way America thinks about and uses jails. But before I share with you why one of the decision points in our approach to thinking about systems reform is the appointment of counsel, I'd like to set the stage by describing the theory of change and the architecture of the Safety and Justice Challenge and the Foundation's initial $100 million investment in its work. The origins reflect MacArthur's longstanding commitment to the fundamental principles and values of a fair, just, and equitable system of justice that treats all people, all persons in conflict with the law with dignity and respect. It stems from our earlier work in mental health in the law and the work that then followed our investment in juvenile justice, the Models for Change, which was one of the signature initiatives of the foundation. The Safety and Justice Challenge builds on this foundation. It has an interplay between policy, research, and practice. It focuses on work on the ground up as well as the top down, and it takes a systems approach. Second slide, please. So why jails? As many have remarked today, we're at a unique moment historically with broad support across the ideological spectrum on the need for criminal justice reform. Much of the attention has been focused on the back end of the system, the need to address mass incarceration and the need for sentencing reform. And usually when I talk about jails, I have to go through a long-standing litany. I've probably had 100 interviews talking about the Safety and Justice Challenge, where first I have to explain the difference between jails and prisons. But at least for this audience, I don't need to do so. But what I emphasize to them is that the problems that we're experiencing today in the growth in incarceration, the unnecessary incarceration of so many individuals, is that it all begins with jails. And when I say jails, I'm talking about the front end of the system, not just what happens from the point of initial contact with law enforcement, through that bringing an individual to jail, to the appointment of legal counsel, how long it takes a prosecutor to file charges, what goes on in the courts and corrections, and then what happens when an individual returns to the community. So if I could have the next slide, I just cite three numbers, or three facts, if you will. I talk about the number of admissions, the 12 million admissions to jail annually, which startles most people. The vast majority of individuals who are in jail are held on minor offenses and are being held pre-trial. The racial disparities are quite dramatic and striking, where over 30% of the people who are minorities in this country are people of color, and yet represent over half of the jail population. So as MacArthur started to look at this set of issues around the overuse or unnecessary use of jail incarceration, it became clear to us this isn't a matter simply of criminal justice reform, but it is also a matter of social, economic, and racial justice. I could have also mentioned, as others have today, about legal fines, legal financial obligations, the mental health issues that drive many people into jails. These are a reflection of practices that are evident and why the dramatic growth in jail incarceration have occurred. But despite all of these sobering, if not staggering statistics, relatively little attention has been paid to local criminal justice reform, where mass incarceration begins. It's both a major driver and element of over-incarceration, where the criminal justice system is experienced by most people, which is at the local level, where the lack of confidence and mistrust in our systems undermines respect for the rule of law, and which takes a toll on our social fabric and undermines the credibility of government action. So why has this problem been hidden in plain sight? Perhaps it is because it is particularly challenging to address the drivers of jail incarceration, because it reflects the discretion of individual decision makers who don't often realize that they are in a system of justice. So these are local problems that require local solutions. The burden falls disproportionately on low-income people and communities of color, or those who are disenfranchised, who suffer from serious mental illness, who have undocumented legal status. I have the next slide first. So when MacArthur issued its RFP, its request for proposals, to local jurisdictions to participate in the Safety and Justice Challenge, we were unsure of what kind of a response we would get. And we were very gratified, if not overwhelmed, by the 191 applications that we received from 45 states and the Trust Territory of Guam to participate in the Safety and Justice Challenge. And so we had the difficult choice of identifying 20 of those jurisdictions with which to partner to both reduce unnecessary jail incarceration and to reduce racial and ethnic disparities. So we've selected 20 jurisdictions across the country that are representative of what jails look like in the United States. And it's our aim to create this network of partners to model and inspire the effects of criminal justice reform across the country. The next slide, please. So MacArthur has no particular playbook. The changes that the jurisdictions are going to be undertaking are based on their analysis, evaluation of their problems and what solutions and opportunities present themselves. Their work, we are confident, will reveal new and better ways of targeting resources, new approaches that foster collaboration, that will improve public safety, as well as the social outcomes that all people are entitled to. The next slide, please. So we have a diverse array of organizations and individuals and groups that are involved in our effort. We're capitalizing on the remarkable work that you've heard about today that the Department of Justice, as well as other private partners in philanthropy, have funded. They're very diverse with respect to law enforcement, judges, prosecutors, and defenders. These groups are incredibly important to us to amplify the results of what takes place in the Safety and Justice Challenge Network to spread reform across the country. Next slide, please. So why defenders? Why have we engaged the defenders in the remarkable work of the Safety and Justice Challenge? As you've heard, it's about the Sixth Amendment. It's about the importance of the role of the defense bar in a fair, just, and equitable system. The speakers and panelists today have spoken much more eloquently than I can about the importance of their role. But we have a more expansive role in mind as a partner in local criminal justice reform than what's envisioned by what is set up by the adversarial nature of our justice system. This is a lesson that has been learned in our work in Models for Change in the juvenile justice system. And others have talked about the needs to have the defense bar at the table. But what we see is not only a role in talking about the importance of the indigent defense bar, but they need to be at the table and talking about the reforms systemically throughout the system. So the Safety and Justice Challenge has required that the public defender be at the table with respect to thinking about the reforms at the local criminal justice system. The Safety and Justice Challenge supports multi-system collaboration about how to come up with solutions to the problem of jail overuse. In all of our sites, the defenders are part of these collaborations. Defenders are in close touch with the impacted people and communities and can help ensure that their interests are represented. So for example, in Philadelphia, they're very much engaged in reviewing the development of a risk assessment tool which will guide pretrial release decisions. They're also ensuring that the community, which has questions about how racial bias might be baked into the tool, are raising those questions because there are concerns about the fairness of the instrument. The defenders are also in a position to surface good ideas. For example, in Pennington County, South Dakota, which is adjacent to the Sioux Reservation at Pine Ridge, one of the largest reservations, tribal nations in the country, the defenders know about the people who are involved in this system. They're familiar with the tribal culture and values and are working to create community services that are alternatives to the use of incarceration. Moreover, as many have already argued, better representation at the front end will help solve the problems. In many places, stronger and more timely representation at initial hearings will be part of the solution to the problems of jail overuse. So we have defenders thinking about innovative ways in which they can look at review bail decisions. They're collaborating with prosecutors and reviewing those cases and trying to come up with ways to divert individuals from the system and resolve their cases without extended jail stays. We see this jail population review team in Lucas, which is Toledo, reviewing the entire pretrial jail population to identify defendants that can be released or referred for expedited case resolution. In Connecticut, there's a collaborative ongoing review team where prosecutors and defenders sit together to routinely review charging documents to identify diversion cases. Frankly, many people are in jail much longer than necessary due to case processing inefficiencies. I was recently at our Safety and Justice Challenge Network where I had the Bronx defender and the Bronx prosecutor agreeing at the need to speed up court processing. So we see rocket dockets in New York and Harris and in Shelby counties, all with the aim of expediting court processing. But let's not lose sight of the fact that funding adequate representation is a public responsibility, not a private one. So MacArthur can help create the table. It can help promote political will. It can give jurisdictions the chance to experiment and innovate with model policies and practices. It can help collect the data and do the research to demonstrate efficacy and effectiveness. But it's going to take all of us, all in this room and beyond, to create this movement that's needed to create a more fair, just, and equitable system. So Defense Bar is a necessary partner in the Safety and Justice Challenge and needs to partner with all of the stakeholders and be engaged in this process with unusual allies and partners. So the progress we have seen is encouraging, and the kind of response and action we've seen at the local level is inspiring, and we will promote and champion this work through the Safety and Justice Challenge. But it's the work of all of you that is critical to make our justice systems more efficient, more humane, and improving the outcomes for individuals, their families, and communities. So we look forward to continuing partnerships with allies that we've already enlisted in our cause, and I hope new ones that MacArthur is always on the lookout for good partnerships and alliances. This is one of the most serious challenges that our country as a nation faces today, and I appreciate the opportunity to speak with you and hope that you will follow the Safety and Justice Challenge. Thank you.
Thank you. We are actually a little bit ahead of schedule, so I'm going to do two things. One is, if people have questions, I think I can persuade Carol and Vanita and Lori to answer some of those questions. Sure.
I'm Judge Marcia Peckman. I'm a federal judge in the Western District of Washington, and I applaud you for all of the things that you're doing today. But I do have a question. Does this side of justice ever talk to the other side of justice about what the other side of justice can do to assist your programming? For example, I just heard that the faster we process people, the fewer days people spend in jail. Well, the faster that Main Justice turns over discovery, the faster people can get out of jail. So there are some simple things that could be done on the other side of Main Justice that would cut down on the cost of how much public defenders are costing.
I'm so glad Carol and Vanita are here to answer that question.
Well, so the person you should have asked that question to is the Deputy Attorney General, who has oversight over our federal criminal justice system. The Civil Rights Division has jurisdiction over state and local criminal justice systems or entities.
So I think the short answer is yes.
Yes,
And
yeah.
actually, part of that happens with people in this room. So as some of you know, the three of us sit down on a quarterly or as often as we can basis with a group of defense advocates, many of whom are here. And we listen to their concerns about how both the federal system works and also to listen to their suggestions about what we might do to improve the situation in the states. And certainly the issue of discovery has come up in that forum, and the Deputy Attorney General was present at the last meeting that we had. The group is meeting again in December, but we will share the concern that you raise with our leadership, because we are one Justice Department, and it is certainly true that we need to have our own house in order before we are out advocating that the rest of the world make
I'm
their-
a
keep
state
their house
court
in order.
judge, but I would like to echo the comments from the federal court. I hope that Main Justice, in terms of your state relations, does encourage prosecutors to say the issue of turning discovery over is a big issue. It's a key component to getting people fairly treated. when there are delays, it ends up having people stay in jail. And this is particularly unacceptable on low-level offenses in which all we have to do is get the police report and we can deal with the case. So that the leadership that could come from Maine Justice is really to encourage state and local governments to say, you have to fix this. We're in an age in which the internet, computers, there's no real excuse to end up saying, well, it takes a month to get a police report. Thank you.
So I would encourage you to talk to Cy Vance and Jeremy Travis, where the institute that I've talked about for innovation and prosecution is going to reside at John Jay College, and they are very much in looking at all of these issues and trying to provide best practices for prosecutors and really do those kinds of reform things. Because if you could have been in the room yesterday to hear what these prosecutors were saying, you would really come out feeling reassured and that everybody gets these issues and everybody understands that we've got to work more collaboratively. Now, I understand it's not uniform across the country, but they understand that they're trying to become leaders on these issues, and they recognize that their role in fairness and people's perception of fairness of our justice system, and they recognize that it will impact their prosecutions if people don't feel as if the system is fair. So these are opportunities for you all to raise your voices and give them ideas about where they can do things that will improve the fairness of the system.
I will also just say I was being a little cheeky about punting it, but really I think one of the consequences of us lifting up these issues and making them such a priority here is that we end up in conversations a lot with groups like the Attorney General's, the AGAC, the Advisory Committee, which is the U.S. attorneys that basically set policy nationwide for federal criminal justice practices and beyond. And these are conversations around discovery issues and the like that they have been engaging in, even as they think through some of the smart criminal justice reform, smart justice work that they've been doing over the last several years. But it's certainly, we feel an onus as well to make sure that we are triggering these kinds of conversations, not just in the work that we're projecting outward, but actually internally as we think through, what are we doing here at the Justice Department. And the good news is a lot of the U.S. Attorney's offices really are kind of looking wholesale at ways to really look at federal criminal justice reform while also kind of doing the civil rights work in partnership with our components. And so it is absolutely a necessary conversation. The discovery issues, I think, are ones that I have been in rooms, and I'm sure Lisa and Carol have as well, with U.S. attorneys that are thinking through these issues.
And I think this is also goes to Lori's point about having defenders at the table. When you have projects like MacArthur's or like any of the grants that OJP issues, when defenders are present, they are able to raise these issues directly with prosecutors, and that's one of the reasons why it's important to have them as part of any criminal justice reform conversation. But because precisely these kinds of issues will stop us from getting real reform if they're not resolved. Yeah.
Hi. I want to take another step beyond the two judges' excellent questions and kind of pose another challenging question, and that is whether DOJ ever addresses internally or with defense bar leaders, I'll call it an incongruity, that our nation's chief law enforcement agency is in such a leadership position with respect to the improvement of indigent defense. And of course, we go to the principle number one of the ABA principles of independence, typically seen as independence from the judges. And I know there are a host of political problems with the concept of an independent Defender General or Office of Indigent Defense federally. I know personally I proposed it at 2013 when Attorney General Holder did me the honor of putting me on the panel to discuss what we should do at the 50th Gideon anniversary. And not only could I not get an independent Defender General, couldn't even get a White House commission. But is that something that either has been talked about or should be talked about between now and January 19th?
As you probably know, there has been legislation introduced in the Congress to create a defender office, and I know our friends at the Constitution Project have been monitoring that legislation, as Preeti talked about at the outset. Without congressional legislation, it's difficult for the Justice Department to create such an office, and might be a little difficult because it wouldn't be independent. We are, as the Joy pointed out, the chief prosecutors for the United States, and I think an independent office is probably more in order. But that legislation needs to make its way through the Congress before we do anything, and frankly, between now and the end of this administration, is highly unlikely that that's going to happen, given that our friends on the Hill have departed until after the election. I will say that those are the kinds of things that I'm hoping you will all talk about this afternoon when you are in group sessions devising an agenda for the next administration, because there is unfinished business, and this may be one of those ideas that a future administration is willing to step up and take on. Yeah.
So thanks again for having me. Quick question, if I can frame my question in this way. So I heard if you print everything from the internet onto paper, it would reach from here to the sun and back, right, without burning up. There's that much information online. The question, though, isn't the information that's available, but what are we doing with it? And so while I'm here listening to this panel and at this particular training, there's a lot of information and how we can collaborate more. But my question is, how do we actually do it? How do we put action to these things? Because as a front line or as a line item public defender in the courtroom in front of the judges, I understand from the MacArthur Foundation there are tables where folks are having these conversations about bail, justice, and all these other items, but I'm not hearing it down on the front lines to be able to articulate these things to judges, to my clients, or anything else on a policy level. So again, my question is, how do we do the things we're talking about? Or are there any jurisdictions that are doing these things in ways that are successful that maybe us back in Charlotte could imitate and copy so that we can do it there as well?
So what MacArthur has been able to do is to identify the jurisdictions where they've acknowledged that they have a problem, that it requires a systemic approach, and that all of the partners have an equal stake in solving the problem. It's very much driven by looking at the data, what the drivers of jail incarceration are, looking at best practices, and then moving to implement them. I don't know that there's anything magical about the way that's accomplished except to be at the table, and that is at least the way in which MacArthur has funded the Safety and Justice Challenge jurisdictions, and that we provided incentives. Now, there still is a challenge, both with respect to the defense bar's participation in these activities, and more importantly, community engagement in an authentic and meaningful way. And you have to provide the training and the tools and the support for them to be at the table and participate, which is why we're partnering with NLADA to provide that kind of resources and support, to network other defenders about how to overcome those problems and challenges, what are effective strategies. But in the end, it does come down to relationships and interactions and developing that trust. And that's one of the reasons why we ask these working groups that are engaged in reform to regularly meet, to have routines, to have all the voices heard. And it's a long slog. We're talking about systemic change, not dropping in a particular tool or a model demonstration project. So all we can do at MacArthur, which is why we took this approach, is to ensure that defense bar is at the table and to somehow remind everyone that they share the same principles and values around a fair, just, and equitable system of justice.
So I've got a couple of suggestions that I would make. BJA puts out smart prosecution and smart defense solicitations regularly. They sometimes alternate which one year it's smart defense and one is smart prosecution. I think you could do something innovative and pair up with your prosecutors and submit a program, submit an idea, because that's what we're trying to do, is spark innovation. We also have technical assistance that's available to you, because what I hear you saying is how do you create the table? We keep saying you need to be at the table, but the question is, how do you get everybody together? So if you feel as if you need some assistance, outside assistance, to get people to figure out how to have that conversation and how to build that network, our diagnostic center at the Office of Justice Programs, we get invited in to help people with the systemic kinds of problems and diagnose the issue and come up with different solutions for you all. And again, that's at no cost to the institution applying for help from us. So I would encourage you to talk to Betsy Griffith or Priya, and they can get you to the right people for those things.
All right, I think we have time for one more question if there is. Sure.
Yeah, yesterday at the Judicial Roundtable, there was a consensus that one of the things that could be done for right to counsel was to ensure that everyone being represented at their first appearance had an attorney. The discussion, though, involved the cultural change necessary to make that occur everywhere. There's places like New York where that's, New York City, it's common. There's places in Michigan where it doesn't happen at all. And the way you have to change that, I think the consensus was both in an individual level, but also at the 30,000-foot level. And I'm wondering what the Department of Justice can do to help us that are down on that lower level raise the discussion so we can change the culture of the judiciary and the criminal justice system generally to ensure that that simple change of having an attorney representing everybody who walks in for an arraignment, first appearance, has that opportunity, because that would change almost everything in the criminal justice system, starting with all those people that are in jail that don't need to be.
So the pretrial detention work that's happening again at BJA, I think, is trying to do that very thing. Again, we have limited resources, but I think that through that network we've been making a big difference, and that's why we're also pushing the risk assessment tool so that you can come up with an objective way of determining who really needs to be helped. So I, again, encourage you to talk to Betsy about the pretrial initiative work that's happening, and if you're not a part of it, how you can become a part of that work.
And let me just say the other thing is sometimes it's useful just to use us as we have, as Vanita said, limited tools, but one thing we have is a voice. And you just heard the Deputy Attorney General talk, all of us talk. We're often happy to come out to jurisdictions or send someone out to a jurisdiction to just sit down with folks and say, this is why it's important. You have people in your community who can, your local defender's office, I'm sure, can come in and talk about why it's important and why it's worth the investment. And Carol's provided a lot of tools that can help persuade data and evidence that can help persuade jurisdictions that there's actually an economic value to doing it as well as a justice and fairness value to doing it. So we are gonna take a very short break because I know we've moved right from lunch to our panel, and then we're gonna come back and work in breakout sessions. I do want to say that this is the end of the open session of our meeting, so we want to thank the media, our friends in the media who have been there, but excuse them from the proceedings at this point. And if you will all please try to be back at 2:05, we will resume. Thanks.